Good afternoon. Today we're talking about construction defense in New York workers' compensation cases, and in particular, where you also have a civil action pending. So we're calling that multi-jurisdictional cases. You've got a civil action pending and a workers' comp case, and your job, claims professional, attorney, adjuster, is to manage those two things. So let's jump in. In today's chat, I have placed in a copy of my partner Tashia Razul's Construction Defense Handbook, and that is currently in your chat. But if you're watching this recorded, and it does seem like most people are watching these in our archive section on our website, you're watching the videos back, you're looking in there, you're finding the right topic. Well, the handouts that come in these live webinars are not embedded in there. So just shoot me a quick email and I will send you off a copy of my partner's handbook. Her handbook is soup to nuts. It is really very comprehensive. And we're just going to really talk about the reasons why you want to think differently about your construction cases where there are multiple claims going in multiple jurisdictions. She lays out in her book a real soup to nuts, beginning to end, everything from setting up the insurance program to the way defense is coordinated between multiple jurisdictions. Very in-depth with chapters, for example, on things like maintaining and protecting privileges and coordinating strategy, and of course trying to reach the goal, which is a global resolution. So take a look at her handbook, and again, my partner Tashia, she's really the expert on this topic. So today I'm just going to give you an introduction to it and sort of talk about what we're thinking about when we have a multi-jurisdictional construction accident in New York. And a lot of this is going to be applicable, and it's going to apply to any cases where there's also a civil action pending, right? Because we're going to be talking about how things that you do or the way you defend the workers' compensation case may have an impact on the civil litigation and vice versa. So these are things that we want to keep in mind as representing clients or representing insureds, depending on which seat you're in. So here's what I'm going to talk about today. First, I'm going to talk a little bit about why coordinate and what are the benefits of coordinating counsel between your multiple jurisdictions. I have to talk about tactics a little bit. I'm going to talk about tactics that benefit the employer and why coordination is important and can be a huge benefit for the employer or carrier. I'm going to talk about reducing litigation costs and putting those litigation costs in the right place. Remember, you're defending cases involving the same claimant, the same fact pattern, the same injuries, and you're defending them in two different courts. So I want to talk to everyone about where those defense costs should probably best be allocated and why you might want to have workers' comp defense do certain things and civil defense do other things. I want to talk about the challenge of collateral estoppel, and for us this can be a challenge, can be a problem. Collateral estoppel is a legal term which means essentially what's been determined in one jurisdiction or one litigation may have an impact, a preclusionary impact, in the other jurisdiction. So we're going to talk briefly about that. And of course, we're going to talk about our goal. And our goal here is to reach a global settlement, one settlement that hopefully wraps up all of the employer or the insured's exposure in multiple jurisdictions. How we structure that and how that's done. Finally, this is totally live, so please feel free to ask questions. There is a question box. If you're joining us live, please type in your questions. If you're watching this back on video replay, of course, feel free to email us or call us with your questions. And call me or call my partner, Tashia, who's really the expert on this. So the big questions is, why do we care about multi-jurisdictional coordination, or why is this a good use of our time, energy, blood, and treasure? And there's really three things I want to talk about. The first is the 3 C's. You're thinking about we're looking typically at a construction case where there is going to be a significant civil action pending, typically under New York's labor law. We're thinking this is probably going to be a pretty big accident, pretty big injury. It's going to be extremely costly. So there's a lot of cost that's going to be driven by these cases. Remember, New York has a kooky system for allocating liability in a workplace accident involving construction accidents. Under the labor law, there's strict liability should the employer have a defect or a dangerous condition. And under the Scaffold Act, there's going to be strict liability for injuries or accidents involving a fall from a height. And remember, your claimant doesn't actually have to fall from a height. just a tool or some part of the workplace, maybe a piece of debris falls from a height. Also, falling into a hole has been determined to be a fall from a height, or stepping into a depression and twisting your ankle, which again is going to engender strict liability for the landowner or the project owner or the general contractor. And so for all those reasons, you're going to really see some big exposures in these cases. And maybe not in the workers' compensation context, but certainly in the civil context, where you're going to see a jury come back and maybe award $2 or $3 million for a relatively minor injury. I'm thinking about things like an ankle fracture or wrist injury, which in the workers' compensation context would be worth maybe 1/10 of that, okay? The next thing is there are 2 different claims pending in 2 different courts, right? Generally speaking, you're going to see that claimants' attorneys are not going to be the same attorneys that are representing the plaintiff in the civil action. So they're generally going to have 2 sets of attorneys. And generally, that's what you're going to see from the defense context as well. But you got to be mindful of what's happening in the other jurisdiction or the other court, because it could have an impact on your case. I'm going to talk about collateral estoppel in a second. So what we've offered clients, and what's really in the heart of my partner's book, is really more of a protocol for how you coordinate defense, where you've got this huge catastrophic loss and with a lot of exposure and liability. We're talking about in the millions in the civil action, and a workers' compensation loss with attendant workers' compensation exposures. And you know these things are going to happen, and you know you're going to have the challenge of coordinating counsel between these 2 different worlds. And so really what my partner has written is a protocol for how we think this should be best be done. So let's talk a little about tactics. Just remember that there's going to be a lot of difference in litigation pacing. The workers' compensation case is going to move pretty fast, right? And also remember, of course, our opponent is going to be using the workers' compensation case to fund and fuel their civil action. What do I mean by that? Well, they're entitled to unlimited medical treatment in the workers' compensation case. So you'll see them seeking all sorts of maybe unnecessary or certainly sometimes not so effective or curative surgeries, treatments, extra physical therapy, anything they can get, because that attorney in the civil action knows, hey, when they go into civil court and they stand in front of the jury, they want to have a big board. And on that big board, they want to have all their specials listed, meaning all of their damages. And they want to show how much money was spent on medical. And they want to have a big number up there that impresses juries and have them come back with a bigger number, right? So the first one is think about the difference in that litigation pending, because I'm telling you, your opposing counsel definitely is. Opposing counsel, again, they want to use the slowness of the civil system and the speediness of the workers' comp system, if you can call it that, and get as much medical treatment and money paid through the workers' compensation system as a way of funding and beefing up their civil claim. And again, just remember, the more treatment the person gets, the more surgeries, the more invasive care, they're going to argue, the more valuable their civil action is. So that difference in pacing, you'll typically see the comp case moving first, moving faster. So that's the thing we're paying attention to. But we have to keep in mind that there's also a civil action pending, even if it's moving quite slowly. So pacing is the first thing. The second thing is, what about disclosure rules? There are differences between the 2 jurisdictions, right? Here's a powerful difference, and something we have to keep our focus on. That is that in a workers' compensation case, if I have covert surveillance or even non-covert information that I want to bring in to challenge the claimant's credibility, think of things like Facebook posts or Instagram posts. Think of things like covert surveillance that would maybe be obtained through the use of an investigator. All of those things come into a workers' compensation case, and I can test a claimant's credibility without revealing or disclosing in advance what I have. In the workers' compensation context, remember that the claimant has to come in and testify, and then we turn over the results of our credibility investigation. That's pretty powerful, and you really don't want to disclose to the claimant exactly what you have, perhaps either covert or non-covert surveillance before they testify. Well, those rules are different in the civil context. In the civil context, when the parties have video or covert surveillance, they have a disclosure duty to reveal the contents of that to the claimant And that can really screw up the case, particularly if on the one side of the house, your civil side of the house, they're disclosing things that we would rather keep in our back pocket, and because we believe they have surprise value in the workers' compensation case. So coordinating who's disclosing what and which side of the house, for example, is conducting that covert investigation into the claimant, that's very important, and that's a tactic that we should be thinking about. Next, remember that opposing counsel in your civil action probably doesn't have much knowledge of how workers' comp works, right? And you'll see this, it's an interesting thing, particularly in New York, where the attorneys that represent claimants in workers' compensation matters rarely, if ever, are also handling the plaintiff's action in the civil court. In fact, I can only think of two law firms. One is the Schwarzkopf law firm, and one is Plata's law firm, which focus on a lot of construction accidents and construction claims that do both sides of the house, right? They're going to handle the workers' compensation case, and they're going to bring the civil action. But that's really the exception. What we really see more typically is it's two different sets of attorneys. And think about the motivations and the coordination between them. Generally speaking, we don't see much, right? The workers' compensation attorney is handling 10,000 cases on the claimant side. They don't know much particularly about any one. And they are really just trying to maximize their claimant's benefit or payments or indemnity in the workers' comp case. That's all they care about, really, because that's what their fee is based on. In the civil action, they've got a completely different motivation. They really want to see a long, big buildup. They want a lot of lost time. They want a lot of curative care. They want to be able to demonstrate a lot of specials on the board when they go in to talk to the jury. So they might not be as coordinated as they should be, and that's an interesting thought. The other thought I have for you is that, generally speaking, the plaintiff's attorneys representing the plaintiffs in civil actions really don't understand how workers' compensation works, and oftentimes really don't have a good grounding in what are the basic benefits and how the benefits work. And even things like how their lien is going to be calculated is something that they might not be aware of. So our tactics are always going to be to try to create as much jeopardy as possible. And creating jeopardy in the workers' compensation case, knowing that the testimony is going to move faster, knowing that the case is going to move faster, what can we do in that workers' compensation case that will help disrupt or maybe reduce the exposure in the civil action, right? Also, knowing about the difference between deadlines and timelines. A lot of our clients where we're representing them in the workers' compensation action, and there's going to be a attendant civil action under the Labor Law Scaffold Act, are public entities, right? They're doing large capital projects, and they're entitled in the civil action to a 50H hearing, which is a hearing that it happens early in a civil litigation involving a public entity, which means we might get multiple bites at the apple at the claimant's testimony. And for that reason, being cognizant of that and having the workers' compensation attorney and the defense counsel that are going to conduct that 50H hearing, communicating and coordinating early can be a really important tactic. So how can we save some money? And I want to talk especially in the context of a wrap-up or an owner-controlled insurance program policy. Let's talk about that. So the first thing is, hey, let's try to reduce litigation costs. Let's have litigation costs done where they can best be done, right? I'm going to tell you right now that the workers' compensation case is often going to move a lot faster than the civil action. And generally speaking, you're going to have your civil litigator go out to the scene and do their first investigation, probably even earlier, or at the same time you're bringing in workers' compensation counsel. So that's something to be mindful about. The second thing is I want us to avoid duplicative efforts, right? We might both be cross-examining the same physicians. How do we coordinate that, right? Why are multiple attorneys subpoenaing the same documents, particularly if we're going to be utilizing them at the same time or in the same way? Maybe an unnecessary or duplicative effort. The last thing I'm going to say is, again, we already talked about how the discovery and the privileges and the disclosure rules are going to be different in both jurisdictions. Keep in mind that what goes into my New York workers' compensation defense file is almost never discoverable in my workers' compensation proceeding. So it's really a good idea to really be mindful about, hey, where do I want this investigation to take place? Which side of the house do I want to do it on? In general, we're going to tell you. For most of the covert and non-covert surveillance and investigation, The workers' compensation side of the house is probably the place to do that, and you'll have the most latitude later with how that disclosure or that information or evidence gets introduced into your civil action. Now, let's talk a little bit about a subject that I've kind of sort of peeked in on or just sort of touched on so far, which is collateral estoppel. And collateral estoppel is a legal principle. I think it's some kind of fancy term. And really all it means is, hey, once something that has been decided in a litigation, that issue is then precluded from being further litigated or further developed later on. And really the idea is to try to conserve judicial resources. And once there's been a judicial decision in a case on a specific topic, well, that's the law of the case until the end of the case, right? I mean, that sort of makes sense. This gets complicated when you've got multiple cases going in multiple jurisdictions, and you want to be very thoughtful about decisions or determinations being reached in the workers' compensation case, because generally they're going to be reached there first, and what kind of impact that's going to have on the civil action, right? Certain things you're going to either want to have decided in the workers' comp case or not, right? So let's talk about something. How about you can use the findings in that comp action as a way of maybe limiting or foreclosing those same issues in the civil action. So a great example of this would be, hey, we've litigated the issue fully in workers' compensation court, and we've got a specific body part or condition disallowed in the workers' compensation case. You can argue in your civil action that, judge, that ankle or that shoulder or that psychiatric disorder, that's no longer part of the case. In fact, there was already litigation on that topic earlier, and here's the result of that, right? So you can try to rely on that to sort of push. Findings by a workers' compensation judge can be binding in the civil action as long as they're considering the same sort of either facts or material circumstances in reaching that determination. So again, think about workers' compensation driving the bus and helping you limit the number of issues or maybe limit the number of claims that the plaintiff can bring in the civil action. So that's very, very powerful. What's the goal of what we're doing here, by the way? It's full and final settlement of both claims in both jurisdictions, right? It's closing out exposure at the same time if we can, and maybe leveraging one case, usually the workers' compensation case, against the other. Remember that under Section 29 of the workers' compensation law, we would be entitled, the employer or the ultimate employer would be entitled to 100% reimbursement for any amounts paid in the workers' compensation case. And again, that could be medical, indemnity, permanent residual disability, anything from the proceeds of the civil action, with just one caveat or one subtraction, which is the cost of that litigation, right? So that whatever attorney's fee or cost and things like expert fees or filing fees would be deducted that. Well, that's important, really, because that means that everything that's going to be resolved in the workers' compensation case really serves as a subtraction from whatever the claimant is going to get in the civil action. In other words, it's not additive. The most they can get is whatever they get in the civil action generally, which is going to be a lot higher than what they get in the workers' compensation case. So that's an important moment to turn around and say, hey, you're going to get $2 million in your civil action. We've had $500,000 of exposure or payment in the workers' comp matter. We would normally be entitled to, I'm just using round numbers here and imagining the attorney's cost of litigation is 30% in the civil action. Hey, we'd normally be entitled to $275,000 or $300,000 worth of reimbursement in the workers' compensation case. However, maybe we will waive some of that reimbursement in consideration for resolving the cases together, right? So we're going to try to use one as leverage against the other, and in that way try to obtain a global or a total resolution of both cases. And that's really our goal, right? The goal here is to both reduce litigation costs as you're proceeding through the case, and that would be by coordinating counsel in each jurisdiction. The second goal would be to use strategic use of collateral estoppel to try to knock body parts or conditions out of the case so they don't end up going on to the big board in the civil action. And the last thing is just thinking holistically, let's move to a global settlement. The other thought, I think that we've done here is a no money moving Section 32 in a workers' compensation case. And in that case, we're saying essentially the proceeds that you're getting from the civil action, we're going to waive our Section 29 lien, and in that way also the workers' compensation case gets settled. Another thing to be thoughtful about is in general, workers' compensation attorneys are not taking fees or getting fees for putting together Medicare set-asides. However, in the civil world, that is a typical thing we see plaintiffs' attorneys asking for, a fee on the amount of money put into a Medicare set-aside. Well, if you're doing some basic global resolution planning or strategy, sitting there and saying, well, hey, I want to put the Medicare secondary payer allocation, whether that's a set-aside or some other technique, into the workers' compensation case so that I don't have to pay attorney's fees on that in the civil action. I mean, there are just a lot of tactics and strategies that we want to employ so that we overall reduce our exposure. All right, I hope I've touched on enough topics to get the juices flowing and get a couple questions going. I'm going to come over here now and open up the questions dashboard and see if I've got any. Okay, Mia said, is there something that's being shown on the screen? Mia, I hope you've been able to see me. I look very nice today. I'm wearing a spring yellow tie. I hope you've been able to observe, but if not, sorry that there's a problem. And Lisa asked the question, hey, Greg, is there specific case law to be referenced when using workers' comp decisions to benefit GL outcomes? Yeah, check out my partner's book. I put it into the chat. There is a lot of information in there that you can pull out, but the case law that stands for the proposition that the determination in a workers' compensation court can serve to preclude or collaterally stop the same issue in the in the civil action is certainly in there. So there's lots of references. And again, if you are facing that in your case, feel free to reach out to us because there certainly is case law that stands for that proposition. All right, aside from Mia and Lisa, I don't see any other questions. So thanks for joining us today. This was a fun topic to put together. Again, I'm not the expert on it. That would be my partner, Tashia, who runs our complex claims practice here, which primarily coordinates the work between civil matters and workers' compensation actions, and primarily in construction cases. But I hope you realize that a lot of what we talked about today is applicable in any circumstance where the same employer, project owner, or premises owner is being sued in two different contexts. So thanks for joining me today. I hope everyone has a great rest of your week, and I'll see you next time.